No, there are a variety of things you can patent about games. That's a great question. Game mechanics themselves can be patented, and there are portfolios that have been licensed kind of throughout various iterations of games. A lot of times when we start working with companies, they think that the inventions are going to come from developers, the guys writing code. That's not really the case. The most valuable patents are going to come from people who are designing the product, from people who are coming up with the game mechanics, from people who are coming up with ways to bring users into the game, from the people who are figuring out how to monetize users, how to get people to spend money in their games, from the people who are figuring out how to encourage their users to bring their friends into the games. Those are types of inventions that are enforceable and are valuable. So the technology is patentable. The how you get your server to talk to the mobile clients and get robust visuals on the clients. All of that stuff is valuable. How do you synchronize a world? All of that stuff is interesting. How do you get rid of having to have a bunch of different servers, or a bunch of different worlds, and have everyone interact in one world? Interesting stuff from a technology standpoint, and perhaps valuable, but technology is going to continue to emerge. Whereas game mechanics that are powerful are going to outlive one particular title, and they're going to be usable across the portfolio. So the game patents are valuable, and they are going to be enforceable. And in the slot machine world, right, that's kind of been shown. These are companies that bring these types of claims against each other on a regular basis. And the reason that a company like IGT has over 1,500 issued patents is because they need them. Right?
I think also it's important not to draw too much of a conclusion from any one situation. Right? Each situation is fact specific, and to emphasize a point that Ben said, many patent cases, when you have competitors go after each other and they both have patent portfolios, it results in a cross license. Or some type of settlement. There might be payment by one to the other, whatever. But again, to the point of it depends on how you look at patents. I mean, if you're acquiring patents, you want to bludgeon competitors to death, and you think that that's going to be a successful strategy, that's rarely the way patents are successfully used. There are a couple of situations where that's happened. More often than not, you want to use them defensively. You want to prevent if a competitor, as a deterrent to a competitor suing you, by knowing that you can countersue them, and what's the point? At a minimum, you want to do that. Or if you do get sued, you want to have some patents so you can create some leverage in the lawsuit so that you can get to the position of settling and moving on with your business. So there's a lot of different reasons. I mean, other companies license out their patents and generate revenue off of that. There's a lot of reasons, but as Ben said, going out and just suing people is not necessarily the only way you can leverage patents in a positive way.
Yeah, and just to reiterate, I think that this particular area is one where it's going to be really important to have some patents that are valuable, because there are so many well-established portfolios in this space where these two traditionally disparate industries, regulated gaming and games, are coming together.
And just real quick, one more point, and then we'll move on from the patents, is that anytime there's disruption in an industry, patents play a key role, and you've seen it probably in no better example than in the smartphone industry. You look at a lot of the traditional handset manufacturers that developed their early basic cell phones, who got business basically passed most of them by. They've tried to assert some of their patents, but more of the innovations and the things that are actually driving the value in smartphones were actually patented now by Apple and others who really helped commercialize that new wave of technology. And you've seen some of the patent wars that have gone on in that space. And for the companies like Google, for example, who really didn't have patents, they went out and acquired portfolios. So there's a lot of positioning going on because, again, Google didn't go out to buy patents to go out and sue people. They did it because they were being sued, and they used them to countersue because they didn't have the portfolio. They paid $12.5 billion for Motorola Mobility, primarily to get the patent portfolio. A lot cheaper to build your own portfolio than to spend that kind of money. Okay, thanks, Ben. So let's talk about the legal landscape and kind of what's legal. So when we talk about the delineation between real money gambling and non-real money gambling, where is that line? It's an easy question to ask, not so necessarily easy question to answer. We're going to talk about some of the principles that guide that answer, and look at some kind of scenarios, fact scenarios, and how the law kind of plays out. So the first thing that's important to understand is that there's both federal and state law in the U.S., and then we're not even really going to cover foreign laws tonight, but if you're going to operate and provide services outside the U.S., you need to be aware of the laws in each country. Within the U.S., with very few exceptions, most of the federal laws that exist that relate to gambling are primarily enforcement statutes, with few exceptions, which means that they are laws that enable the federal regulators to go after people if they do something that's illegal under either federal law or state law. So Melissa talked about the DOJ position on the Wire Act. So the Wire Act is a very significant statute. It now primarily limits sports betting. The other kind of major piece of federal legislation that was most recently enacted is UGEA, and it really doesn't define what is illegal gambling. It basically is an enforcement statute that enables the feds to go after anyone who's involved in processing a financial transaction for an activity that constitutes illegal gambling under federal or state law without defining what gambling is. So if you're guilty under a state statute or multiple state statutes, and you're a payment processor, this is a law that can be used against you. Now, one of the interesting things, just as a quick side note, a number of people, as Bitcoin became more popular, was like, well, Bitcoin's a distributed currency. There really is not a payment processor. Can we use Bitcoin and get around the gambling laws? Melissa, can we?
I don't think so.
Right. It's only one statute, right? There's still state law, right? So you may, right, even if UGEA doesn't apply, you still may be gambling because, as we'll see in a second, what matters is whether you're wagering or staking something of value, and Bitcoin clearly has value. You can buy it and sell it for real dollars. So for anyone who has, and there's been companies who have actually publicly said we're going to set up gambling operations based around Bitcoin, and the feds can't touch us. It's not true. So if anyone thinks that might be a safe way, I would suggest rethinking that. Okay, so yes, question.
Since Melissa's in the audience, why? So the Wire Act traditionally was all gambling, and then got reinterpreted as just everything other than sports betting is now legal, and you were involved in that. Why is sports betting different than like straight up games of chance, and why is that considered different? Given that in the UK, especially online and mobile, it's probably the prime Betfair, as well as like a dozen other legal regulated sports books.
So the very short answer to that is just the sports leagues and how they feel about that, and the political influence they have. But with regard to the Wire Act, it was a federal law that was enacted in 1962 before there was any kind of internet, and the whole purpose of the Wire Act was to deal with the criminal activity going on with illegal sportsbook operations. That was the whole intent behind it. It had nothing to do with the internet or internet wagering. It was just, as time progressed, for various moral and political reasons, it had been interpreted to encompass all kinds of wagering on the internet across state lines, including wagering authorized by state law. And that was something that we had to really dig into the history of the Wire Act, the reasons why it was enacted, and the public policy implications of what would occur if the federal government continued to take that position when 48 states were undergoing huge budget deficits in 2009, and the feds were saying basically you cannot utilize your gaming assets in a way to monetize them online as 85 other countries in the world are doing. We really got them to interpret it the way it was intended to be interpreted, which was only with regard to sports betting.
One thing I just want to note that might be relevant to some game companies is that there's an exclusion in UGEA that many people don't talk about, but there's actually two exclusions. But the two things that are excluded are up here, and the first one is anything that requires just personal efforts. And there's some states, when you look at whether you're wagering something of value or you're staking something of value, in some of the analysis for some of these legal issues, if there's a significant expenditure of time, that can be deemed to be consideration and part of putting up value. This was, under UGEA, they exclude, as you see, the personal efforts of someone playing a game, that's not going to, that's going to fall within the exclusion. And the other one is if what you're wagering is points or credits that the sponsor of the game or contest provides to participants free of charge, and that can only be used within the game. So this actually I think is very helpful for social game companies. So when you get to the question of whether using virtual currency is an issue, at least under federal law, if you're issuing it and you're issuing the currency for free and people are playing within your game or on your platform, the UG is going to have this exception, which likely will apply depending on how you set things up. It may or may not get you around the state laws, but again, just note that it's here from a federal law perspective. So the fact that UGA, and these other statutes are really primarily enforcement, with, as I said, with limited exceptions. The real law that you need to be concerned about is the law of the states, and each state has laws. Pretty much each state has laws on lotteries, and some have laws on gambling as well. Many people kind of equate the two and think if you have an illegal lottery, you have illegal gambling. There are situations where you can have one and not the other, but in many states, the elements are pretty much the same. Okay, so let's talk about the elements real quick. So this is a gross generalization, but for the most part accurate, and to avoid having to go through 50 state laws in the night here, if you have the following three elements, you probably have an illegal lottery and likely illegal gambling. Payment of some form of consideration. And consideration means something of value. So clearly if you pay money, that's value. There's other stuff as well we'll look at in a second. If you have a result determined by chance, and we'll look at what chance means under different state statutes, and it results in someone getting a prize having value. If you have all three of those components, it's typically illegal. So the goal in trying to create a legal gamblification offering is to eliminate at least one of those three components. And typically, if you eliminate payment, so there's no consideration up front, so you can have chance determining an outcome and you can have a prize, that's typically a sweepstakes, right? So if there's no cost to enter, it can be pure chance-based and subject to other requirements under sweepstakes law. It can otherwise be legal, but at least not an illegal lottery. If you remove chance, right, so you can have payment by people and you have a skill-based determination. So and we'll get to the distinction between chance and skill, but in general, if the outcome of who wins a prize is based on skill rather than chance, then that's typically deemed to be a contest. So if it's a athletic endeavor or if it's a intellectual endeavor like a trivia question, something that's not determined by chance but rather by some element of skill, that can be legal. And the third way to do it is to eliminate the prize. So if you have consideration, so people pay money for a chance to win nothing, you have a legal model. Now who in their right mind would pay for a chance to win nothing? Gamers, right? Think about Zynga Poker. People buy poker chips for real money, they play poker, and what do you win? You win poker chips, but you can't cash them out. So there's nothing of value, tangible value, but the winning is what drives people to play the game. So that's kind of at a high level, the regulatory framework that we need to kind of work with, right? So it seems like a pretty easy three-part test. Prize, chance, and consideration. Very easy to say. Let's talk about why it's not. So when we talk about consideration, clearly money is consideration, but what else is, right? And I don't know, unless you want to talk to us a little bit about, and again, 50 states, so we're not going to be able to cover each of them, but there's other types of things that can be consideration as well.
Sure. For example, if a company requires you to devote a significant amount of time filling out a survey or providing information about yourself, that could be considered consideration. And there are some businesses out there that are trying to formulate a business model based upon individuals providing feedback and information regarding preferences as it pertains to brands and various items, and allowing those entries, as they call it, to be randomly selected in a sweepstake type situation, resulting in a prize. The problem with that is it's more likely than not that the level of information they're requiring that customer to provide is going to be considered to be consideration under numerous state laws. So that's one example.
So there's a couple of kind of common scenarios we'll talk about real quick where the element of consideration, depending how you look at it, might be a problem or it might not be. It's very common for companies to do product promotions. One of the most famous ones, McDonald's Monopoly game, right? How many of you have you purchased the Big Mac and gotten a little token, and if you kind of get a whole set of those tokens, you win a prize, right? Why is that not illegal? You're paying money, right, for the Big Mac. You're getting a token, and there's some element of chance of what you're going to get, and there's a prize if you win. Well, the reason that it's not illegal is, actually it's not a fair question because I didn't give you all the facts. There's a fact missing, is that the way that they get around it is that you don't have to purchase the Big Mac to actually get the token. So you probably have seen, write in, and you send a self-addressed stamped envelope and we'll give you a game token for free. It's called a free alternative means of entry. So the fact that you purchase something and you're getting something of value for what you purchase. So in this case, you're paying your $1.99 for your Big Mac or whatever they are these days. You're not purchasing the chance, you're getting a chance in association with a purchase. Very fine distinction. And we're gonna come back when we talk about enforcement to a model that was very similar to the McDonald's Monopoly game, but we're gonna change one fact and we'll see how that changed the outcome. So that's kind of a common thing. And so there's a number of companies that are doing things around that with virtual goods and virtual currency and other types of things where in conjunction with purchasing something, whether it's virtual goods or virtual currency, you may get chances to win something else. Right? Those things can be legal. You need to structure them in a way that complies with the free alternative means of entry and other requirements that would be consistent with traditional sweepstakes or promotions law under each of the state laws. Okay, so that's that. Next one, American Idol. American Idol has done these text-to-win sweepstakes, where they'll have the audience be able to vote. You'll send your text vote in, and they randomly draw, and you get a chance to win. Believe it or not, that was actually found to be illegal under a number of states' laws. And the reason was there was a charge for sending the text. And it wasn't the standard text charge. They were doing a premium charge. It was like 95 cents. Courts have found that to be consideration. They shut that down. There was significant penalties, like tens of millions of dollars in penalties. And they're like under some 20-year consent decree not to do similar activities in the future. Again, subtle facts like that can change, whether if it's a free text, it's probably okay. And this is an area where the law always lags behind technology. Florida used to, the Florida AG took the position early on in the days of the internet, if you had to enter a sweepstakes online, that the fact that you had to pay back then for dial-up service, and if anyone remembers that, that was deemed to be consideration. And of course, like about a year later, they reversed that, saying that's kind of silly. Everyone now has internet, and you really weren't paying to enter the sweepstakes. People were getting their internet service anyhow. So some of those technology issues and kind of the what constitutes consideration can be subtle. The internet questions are kind of long ago resolved, but some of these models like the text-to-win sweepstakes are fairly recent cases. The last one I'm going to talk about is fantasy sports. So fantasy sports, you pay money to enter a league, right? So that's consideration, right? You have a chance to win, right? I mean, if your player that you designate for your team that week is hurt, right, and he doesn't play, that chance element impacts the outcome, right? So there's probably chance involved in determining who wins the fantasy sports leagues, and of course there's a prize. Is that legal or not legal, right? You have the three elements, probably, right? Consideration, chance, and prize. Why is that? Why do people get away with doing that? Interesting, there was a case in Jersey that decided that the reason that is not illegal, well, first of all, under UGA, there's a specific exemption for fantasy sports. Their lobbyists did a good job for that. But under state law, most of these laws were written before fantasy sports or even the internet was thought of. So the laws don't exempt out things like that. The reason, according to the Jersey court, and again, this does not necessarily apply to all 50 states, is that they said that the money you pay up front is not consideration. You're not paying for a wager or a bet. What you're doing is you're paying for a service. You're paying for the entertainment value of playing, and that the money that is being paid, there's servers and other stuff that's going to support the service and to enable you to have fun and play with your friends and all that kind of stuff. It just goes to show that, like, sometimes courts will make decisions based on a set of facts, and two different courts look at the same facts and come to two different results. In fact, in the American Idol case, there was one court that found that that wasn't a problem, that the SMS text fee, another court did. Some of these issues are just gray areas, and it's really hard. As Gerard mentioned, what you do in some cases for the states that are on the fringe, you stay away from those states. You make your offerings not available in those states, if that's feasible and with your business model. But anyway, so the point here on the consideration is you have to really think about when money is being paid, what is it being paid for? Are you buying your Big Mac and getting something for free? Are you paying for a service and entertainment and you're getting a chance along with that? Or are you really paying for the gambling itself? And the analysis can really change based on very subtle facts.
For fantasy, are you talking about the entry fee like CBS Sports, or are you talking about the fact that you pool money together with like friends and the winner? Or
the fantasy sports leagues where you pay an entry fee to play online. Okay, so that's kind of the consideration piece. Chance versus skill. Liz, you want to take this one?
Yeah, I mean, I think that, that's a really fine line that you play with, because I think that different states have different definitions of what is a game of chance versus a game of skill, and they have different types of tests for determining chance versus skill. Is it predominantly chance with a little bit of skill? Is it, material degree of chance? And I think, from my perspective, I'm a serious poker player, and I think poker is a game of skill, in my opinion. However, you have numerous states that have pretty much determined one way or another that it's a game of chance. So when you have a game of that nature, which I think requires a high level of skill being determined by some states to be a game of chance, I think you have to be very, very careful that if you're trying to use a business model that's dependent upon it being a game of skill, that you consult with your attorneys and try to really figure out if there's a defensible position that is truly and purely a game of skill versus something that could have some element of chance, and in what states do you think you're going to be okay with that in?
So again, just to emphasize what Melissa said, I mean, it's very fact specific, and that's sometimes, depending on the nature of what's determining the outcome, you need to make sure that if that's the element you're trying to rely on, that it's a skill-based event, you want to make sure you're solid on that. And again, in some cases, there's certain states that have the test where if there's any element of chance, it's deemed to be chance. You may want to avoid some of those states for some activities. So then the last part of the test is prize. And this one generally seems pretty simple too, right? So if you're winning a car or you're winning money, that's a prize that has value. But there's many other things that can go into the analysis of whether something has value. And particularly when you think about, I mentioned like Zynga Poker before, you can't cash the chips out, right? So people would, the reason that they do what they do, and no one's really stopped them. The theory is that the poker chips have no value. There was a case in the UK where a guy hacked into the servers over in London that ran Zynga Poker over there and stole the equivalent of what would have cost you $12 million to buy those chips. And the guy was arrested for theft. And his defense was, I didn't steal anything of value, because Zynga says these chips have no value. The guy was convicted anyhow. It was a criminal case, so there was really no decision that helps us as lawyers to figure out kind of the analysis that was applied over there. But it does raise an interesting question of when does something, even in a closed loop system that you can't cash out, when could those have value? When could that item have value? And we're going to talk about in a second. There's one case that's particularly, I think, interesting and relevant, even though it wasn't a games case. It involved the NCAA lottery, in which the NCAA used to award tickets to the men's Final Four basketball games, which were very sought-after tickets. They did it in what they deemed, they called a lottery fashion. Probably not a good choice of words on their part, because lotteries are illegal, as we now know. But what they did was, the way that it worked, and actually let me kind of jump ahead to that real quick, we'll talk about it. Let me mention one more thing which way. So one other issue that really kind of plays in with, particularly with virtual items, whether virtual good, virtual currencies, or other things, is what role, if any, do secondary markets have in determining whether these items have value? And it's a question that a lot of people have thought about, written about, pondered about, and there's not really any definitive, clear answer. But the issue, to kind of frame it, is that if you can sell virtual items on a secondary market, and we all know that for virtual goods and currency, there are secondary markets out there. You can sell entire accounts. If those markets are available, and you can literally cash out, even let's say like Zynga poker chips, does that mean those chips have value if there's an established market for them? And it's an interesting question, and it's an important one in assessing. And again, I don't want to pick on Zynga. I'm just saying it's just because it's well known. If there's a secondary market for those chips, and a court determines, well, that means they have value, well, that might change the analysis of whether what they're doing is legal or not legal. So this issue is a really important issue. There's one case I think that's really interesting that at least is one court's take on this that's analogous, and that's the NCAA case that I mentioned. The way that it worked was, if you wanted to buy tickets at $150 face value, you would send in a $6 processing fee and the $150 per ticket, and you could request, I think, up to 4 tickets. And they would do a drawing, and whoever got the tickets, they would keep your $150, send you a ticket, and keep your $6 processing fee. For the people who didn't win, they would send you back your $150 and keep your $6 processing fee. And they ended up getting sued for running an illegal lottery. And the theory was you were paying $6 for a chance to win these tickets. And this case went from the district court to the appellate court to the circuit court and back down. It's like decisions all over the place. It's like a lawyer's dream or nightmare, depending on your perspective. And there's opinions all over the place. But one of the issues in the most recent decision from the appellate court focused on whether or not these tickets even were deemed to be a prize under the lottery and gambling law analysis. And the argument in favor of them being a prize was that because these tickets were in such demand, that the moment you got these tickets, you could sell them for multiples of what the face value was to scalpers or other people. And so therefore, you're paying the $6 to get a chance to pay $150 for something that's worth a lot more than $150. So that was the argument. The counter argument was that the secondary market is irrelevant. It doesn't matter that you could resell these tickets. You were buying a ticket that had an established face value from the NCAA at $150, and that's what you were buying. Who thinks that under what we've talked about so far, is that a prize for purposes of this analysis, or having value, or is it just a purchase of an item for face value? Who thinks it's a prize? Less than half. And who thinks that it's not a prize? And others don't have an opinion. Okay, good. So the answer is the court found that it actually was not a prize. They said that the secondary market didn't matter in this case based on these facts because, and this is why it's important to game companies, is that the NCAA itself made the market for these tickets, and that the market didn't exist before they issued the tickets. So, and they also threw in that you only get a license to the tickets, and that by selling a ticket, you're really foregoing the license, is what you paid for in the first place. So the fact that these were licensed, again, was also analogous to kind of virtual items. But the key point there is that, I think to extrapolate for game companies, is that there's a difference between if you're charging someone $6 for a chance, and to pay $150 to get an ounce of gold, which is now worth $1,500, wherever the market is today, where this is a commodity or an item that is a pre-established market, you don't create the market for it, that would probably be an illegal lottery under that analysis. Whereas here, because the NCAA actually issued the tickets and they created the market in the first place and they set the value and all that, it was deemed to be legal. So I think from that point, I think that's a helpful decision, at least under that. That was an Indiana court and Seventh Circuit analysis. Is there a question back there?
Yeah, I'm just curious. In this case, is it relevant whether the secondary market is legal or permitted? So if scalping is legal or selling tickets above face value, is that relevant to the fact that in the case of Zynga, Zynga says you may not transfer chips to another person, and people find a way around that. Is that relevant to the secondary market test?
That, to my knowledge, that was not brought up as a relevant factor here. regardless whether it was legal or illegal secondary market. Okay, so anyhow, so that's just, I think, that just goes to show there's some subtleties here in deciding whether something is a prize having value. When you deal with virtual currencies, if you're dealing with a, kind of a closed loop system, and you can only use the currency within the game and only with the issuer, you're probably on the safer side under at least most states. And if it's more of an open loop currency or something that can be used across platforms, certainly something like Bitcoin, which can be exchanged for real money, if that's what you're playing for, then you're probably more likely to be on the end of the scale where there is value. Okay. So that was that. So the other thing I want to talk about then is a couple. Yep, Justin.